How AFER fights for marriage equality. November 2008, Prop 8 passes in California, eliminating the freedom to marry. AFER brings together Ted Olson and David Boies, who faced each other in Bush versus Gore to fight Prop 8. Ted and David sue California on behalf of two couples, Sandy and Chris and Paul and Jeff. They represent countless committed gay and lesbian couples in California who want to get married. AFER sues California for violating the due process and equal protection clauses of the 14th Amendment. Due process is the legal requirement that the state must respect all of the legal rights that are owed to a person. In other words, we are all protected from government intrusions into life, liberty, and property. And equal protection says that no state shall deny to any person within its jurisdiction the equal protection of the laws. Or in other words, laws must apply equally to everyone. Prop 8 violates both. In January of 2010, AFER puts fear and prejudice on trial. It's the first time a federal court hears testimony on marriage for gay and lesbian Americans. We had 17 witnesses. They had 2. And one of them changed his mind and now says, legally recognizing gay and lesbian couples and their children is a victory for basic fairness. On the witness stand, the truth came out. Witnesses said, the ability to marry, to say I do, is a basic civil right. If government tolerates discrimination against anyone for any reason, it becomes an excuse for the public to do exactly the same thing. It is, I think, quite clear that young children do not aspire to become domestic partners, but certainly the word marriage is something that many people aspire to. Prop 8 has inflicted substantial economic harm on same-sex couples and their children who live here in California. It is very hard for me to imagine you would have a happily married couple who would say, Gertrude, we've been married for 30 years, but I think we have to throw in the towel because Adam and Stuart down the block got married. August 4th, 2010, the verdict. Victory. The court concludes Prop 8 is unconstitutional. Because California has no interest in discriminating against gay men and lesbians, and because Proposition 8 prevents California from fulfilling its constitutional obligation to provide marriages on an equal basis, the court concludes that Proposition 8 is unconstitutional. And on February 7th, 2012, once again, victory. At the Ninth Circuit Court of Appeals, the court concluded Proposition 8 serves no purpose and has no effect other than to lessen the status and human dignity of gays and lesbians in California. The Constitution simply does not allow for laws of this sort. Meanwhile, over 20 polls show a majority of Americans support the freedom to marry. And Dustin Lance Black's play 8 about the trial is a hit across America and around the world. Now Prop 8 has reached the highest court in the land. The U.S. Supreme Court will hear the case and consider whether Prop 8 violates the U.S. Constitution, paving the way for a Supreme Court ruling on marriage equality for gay and lesbian couples. Oral argument is Tuesday, March 26th, and a final decision is expected by the end of June 2013. Since 1888, the U.S. Supreme Court has ruled 14 times that the freedom to marry is a fundamental right of all Americans. There is no legitimate reason for the government to deny gay and lesbian Americans the freedom to marry the person they love. Prop 8 will soon be gone forever, thanks to AFER's bipartisan coalition, brave plaintiffs, and the support of millions of people like you. But it's not over yet. We need your support now more than ever. Click here or visit AFER.org to support our case and join us on the right side of history.